Okay, Mr. Church, which client would you like to address first this morning?
Mr. Vancle here.
Okay. Mr. Vancle, if you can come forward, please. We'll go on the record in People versus Kyle Vancle. This is file number 265503. The record should reflect the defendants present here in the courtroom today. If I could have counsel for your opinions.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Richard Church appearing on behalf of Mr. Vancle. This is the date and time for a status conference. I think this is our first status conference in the circuit court. However, we're going to be asking the court to docket the matter for a trial. I don't think there's any specific time frame that we would need to be ready. There is a companion NA case, which I think is also docketed for a trial. But frankly, I don't know if there's any reason one should go before the other.
Okay, Ms. Coke, how many days, of trial do you think you would need in this case?
I think it's actually going to be a short trial. I'm hesitant to say 1 day, but we really only have one or two witnesses. So depending on what the defense does, I think we could probably do in a day.
I mean, just looking at the nature, I think we should set it for 2, just in case it takes longer to pick a jury.
Okay.
Do you have any objection to that?
No, I think it's prudent. I tend to agree with the prosecutor. I would say I'm cautiously optimistic we could do 1, but I think it's better to schedule 2 and get it done in 1 than schedule 1 and have everyone's schedule get messed up.
Okay. And Ms. Coke, how far out do you want the court to set this?
We can set up the next available date.
Mr. Church?
Again, I think that's fine.
Okay. Ms. Coke, are you anticipating any motions being filed prior to trial?
We may file on notice, but other than that, no.
Mr. Church?
I don't anticipate any pretrial motions. I guess I would ask the court to give maybe a 30-day window, just so we can take a closer look at it.
Okay. All right, so we'll set this for a 2-day jury trial in the court's next available date, which I'm sure will be at least 60 days out. And then we'll set it for final status conference. That'll be complete cutoff. So Mr. Vancle, prior to your trial date, we'll have 1 additional hearing. That would be your last opportunity to enter into any plea agreement if you wanted to do that. So just make sure that you stay in touch with your attorney and so that you're prepared to make that decision at that time. And then otherwise we'll set it for trial. You'll get notice of both of the dates of that. But again, between now and then, it's just important to stay in touch with Mr. Church. Ms. Coke, is there anything further on this file that we need to address?
No.
Mr. Church?
No, Your Honor.
Sir, do you have any questions about how we're going to proceed with your case?
No, sir.
Okay, thank you.
Stay in touch.
And do you know who the gentleman is that you're in the phone?
That's Mr. Donigan.
Okay. Mr. Donigan, are you able to hear me okay?
Yes, sir.
Okay. All right, we'll go on the record in People versus Daniel Donigan. This is file number 255510. The record should reflect that Mr. Donigan is present today by video from Macomb County Jail. If I could have counsel put your appearances on.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Richard Church appearing on behalf of Mr. Donigan. Just by way of a little bit of background for the court, so this was, I think, originally set back in February. I had met with Mr. Donigan just prior to that hearing. That hearing got moved because there was an issue with the writ in regards to Mr. Donigan. So effectively, Macomb told us they couldn't have him available. He was rescheduled, and then that hearing got adjourned because of the ice storm that had come through and the weather issues. So that kind of brings us to today's date. We had anticipated and planned to take advantage of a plea agreement. We had indicated at the last hearing we were before the court that we intended to take advantage of an offer to an added count 4 of CSC in the 3rd degree and count 3 possession of child sexually abusive material. And we intended to tender that as a no contest plea. At that time, the court had effectively told us, I want to see the rationale for the no contest plea. Honestly, I think it was more directed at the prosecutor than me, but I filed a memorandum of law essentially outlining the rationale for why it is that we think it's appropriate to do that. So we would be seeking to enter into that agreement, assuming the court's prepared to allow that.
Okay. I did receive that memo. I did have an opportunity to review that prior to the hearing today. And I find that there is a reasonable basis based on the information you provided, and I do appreciate that. I do typically have problems with taking a no contest plea to charges like this, but with that added information, I do think it would be appropriate. Ms. Cope, you don't have objections to the no contest.
I don't, because he is correct. There is a whole nother case happening in another county. And we talked about that ahead of time. And the offer, just, I think Mr. True said it correctly, but it is to an added count for criminal sexual conduct, 3rd degree. PAT code 750.520 D1A, and count 2, which is child abuse material aggravated possession.
Okay, Mr. Truce referenced count 3, so I want to make sure we clear that up.
I don't know, was there one?
Well, we changed it. That's different than the order I had. Let me check and see.
What we're doing that, do you have the police report? Was that submitted already?
I did not submit a police report. What I had anticipated, so there was a search warrant done for his cell phone. My anticipation or my request would be that the court rely on the affidavit from the search warrant, which outlines the investigation. And I took the liberty of highlighting, I think, the paragraphs that would provide the basis for the court.
Okay, great, thank you.
Thank you.
Approach with that.
He does have the correct plea offer.
Count 3.
Yes,
And what is the maximum penalty for the CSC 3rd degree? Is that 15?
it's 15 years.
Okay, Mr. Donigan, we've been doing a lot of talking here about the plea agreement, but under this agreement, you would be pleading guilty to count 3, which is possession of child sexually abusive material. I'm sorry, you'd be pleading no contest to count 3, and no contest to an added count 4 of criminal sexual conduct 3rd degree. Have you discussed that plea agreement with your attorney?
Yes, Your Honor.
And is that the agreement that you'd like to go forward with here today?
Yes, Your Honor.
Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. You can lower your hand. And Mr. Donigan, are you currently on any kind of probation or parole?
Yes, Your Honor.
Okay, is this pretty in effect?
And I don't think he's actually on probation or parole. I think he has the other charge.
Okay. Is that bond for,
He's technically lodged for it. Yeah.
Yes, that is correct. He is on bond.
Okay, so Mr. Donigan, you understand that by pleading no contest to count 3, again, which is possession of child sexually abusive material, that carries with it a maximum possible penalty of up to 4 years and or a $10,000 fine.
Yes, Your Honor.
And that by pleading no contest to count 4 criminal sexual conduct 3rd degree, that carries with it a maximum possible penalty of up to 15 years. Do you understand that?
Yes, Your Honor.
With those maximum possible penalties in mind, what is your plea to each of those charges today?
No contest.
Right now you have certain rights. I'm gonna go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you want it. You understand all those rights.
Yes, Your Honor.
And you understand that you're giving up and waiving all of those rights by pleading no contest.
Yes, Your Honor.
Does anyone, I'm sorry, also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it, you would have to ask for leave to do that. That means you'd have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. Do you understand that?
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead no contest?
No, Your Honor.
Has anyone promised you anything other than what we've discussed here in court today?
No, Your Honor.
Is it your own free choice to enter into this plea?
Yes, Your Honor.
All right, so Ms. Koch, I'm marking as Court Exhibit 1 of the affidavit, which is referenced as number 25-828. Have you had an opportunity to review that document?
Yes.
Signed by Sergeant Kozakowski. Okay, and in particular, paragraphs F, K, L, and N. Would you agree that the information contained within that would provide a factual basis for finding of guilt as to both charges?
I do. And we stipulate to the age of the victim being between the statutory requirement.
Thank you, Mr. Trush.
I would agree. And we also would stipulate.
Okay. All right. Ms. Koch, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, other than what we've talked about with the other case, which is frankly the controlling case, but there's no threats or inducements in our case.
Mr. Trush.
I'm aware of no threats, promises, or inducements.
Ms. Koch, are the people satisfied that the court is complying with statute and court rule in taking this no contest plea?
Yes.
Defense is satisfied.
All right, Mr. Donigan, the court finds that your plea is knowing and voluntary. I've reviewed what I've marked and will admit as Court Exhibit 1. I do find that it would provide a factual basis to support finding that you are guilty of each of the charges in this case. The court will accept your no contest plea. We'll set this matter for a sentencing hearing. Is Mr. Donigan going to be lodged in the home for some period of time?
I expect he will be. However, I think it's academic, but I think under statute, the court has to revoke its bond to the extent that there is a bond.
Correct. Okay. So Mr. Donigan, we're going to have a sentencing hearing in this case. You do have the right to have that hearing in person here in the courtroom in Crawford County. If you wanted to exercise that right, then I would sign an order to have you transported here for the purposes of that hearing. You can waive that right and we can have that hearing by video as we're doing today. Do you know how you'd like to proceed in that regard?
I would rather do a video hearing, Your Honor.
Okay, so the record will reflect that Mr. Donigan has waived his right to an in-person sentencing. We will set it by Zoom. The court, as indicated by Mr. Trush, pursuant to statute, will revoke Mr. Donigan's bond in this case. And it'll be held without bond pending sentencing. Ms. Koch, is there anything else we can address?
I would just like to ask if Mr. Donigan knows the status of his Macomb date, where he'll be in about a month, so that we can do the writ to the right place.
That's why I was asking Mr. Trush. It sounds like he's going to be in the home.
I believe so. The last communication that I had with his attorney there is they were still kind of waiting on this while they have some potential resolutions there. So that was my understanding, is he will still be there.
Anything further from your side?
I would just ask if we could, if the court could set it on the mid-month day in May, just because Mr. Donigan's requested to appear via video, which I think is fine. I need to make sure, I think, that I have time to get to Macomb to meet with him, and having it in a full motion week may make that difficult.
Do you have any objection to that, Ms. Coe?
No, with his bond being revoked, I don't have any concerns.
Okay, so Mr. Church, I'll note that for Jennifer. Said that.
I appreciate that.
All right, Mr. Donigan, do you have any questions about how we're going to proceed with your case from here?
No, Your Honor.
All right, thank you. The court is going to disconnect from the phone at this time. Next matter is People versus Joseph Roby, file number 265520. Mr. Roby present.
Richard Trush on behalf of Mr. Roby. Your Honor, he is not present today. I was notified this morning that he is lodged in Grand Traverse County.
All right, so we need to reset this, and Ms. Coe, can you prepare a writ for Mr. Roby, Grand Traverse?
We can. We did not know he was in Grand Traverse County. I just learned that information about 20 minutes ago. I don't know how long he's going to be in Grand Traverse County, but we will do a writ. If he's still there, we'll have him writted.
Okay. I mean, my understanding is it's a misdemeanor, but I don't have a lot of information about it.
Okay. Thank you. People versus Scott Love. Is Mr. Love present?
He is, Your Honor.
This is file number 265536. The record should reflect Mr. Love's present in the courtroom today. If I could have counsel for your appearances on this file.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Richard Trush on behalf of Mr. Love. This is our first date in the circuit court. We have an offer from the prosecutor. There's a few things I think we still need to clean up before we'll be ready to resolve it. Specifically, Mr. Love is presently working with CMH. We're likely going to ask them to create a diversion plan to submit to the court. So that's still something that needs to be done, as well as we've been going over the scoring. We've got a little bit to clean up there as well. I would suggest to the court 30 to 60 days, I think we'll likely be in a position to resolve this case.
Okay, Ms. Coe, do you have any objection to that?
Your Honor, I would ask that the next court date be the plea cutoff. We've been dealing with this case for several months now. So if it's going to go to trial, let's get it set for trial. If it's going to be a plea, let's get it set for a plea.
Okay, so Mr. Trush, I'll set this for a status conference plea hearing in about 60 days.
That would be perfect.
So Mr. Love, between now and then, make sure you stay in touch with Mr. Trush. I will make that the plea cutoff. So there is going to be an agreement. I'll need you to be ready with the final decision on that at that next year. Okay. Do you have any questions? No, I do not. Mr. Trush, anything else on this file?
No, Your Honor, thank you.
Ms. Coe?
Nothing. Thank you.
Thank you, Mr. Love. Again, just make sure you stay in touch with Mr. Trush. I will. Thank you. Have a great day. People versus Daniel Roden. This is file number 245286. Roden's present here in court today. Counsel for your appearances on
Sierra Coke on behalf of the people.
Thank you, Your Honor. Richard Trush appearing on behalf of Mr. Roden. Your Honor, so this was set for a probation violation hearing. This is a situation, I think the only basis for the violation is that he hasn't completed payment on his fines and costs. I had an opportunity to talk to Mr. Roden about it. He was hopeful that his tax return was going to give him the ability to pay it. Unfortunately, that got garnished for some medical bills he had outstanding. He is working on getting that done. He reports to me, I think he has about $800 or so outstanding that he's got to take care of. I reported he can make a payment today. It's not a huge payment, but it's still a payment. In addition to that, I intended to ask the court if a court-appointed attorney fee has been assessed on this. I would suggest to the court, given the medical debt that he has and his current circumstances, it would be appropriate to waive that if it has been applied. And I know that generally when I ask that, the court's response is that the court shouldn't address that until it's looking to take enforcement action on non-payment. That would seem to be now.
Mr. McDowell.
I've had, well, first of all, Judge, his 2-year max date on this misdemeanor probation term is up on 15th of this month. I've had several conversations with Mr. Roden last month or so, and again this morning. He has completed all terms of his probation, his counseling, he's been complying other than this payment. He's given a commitment to have this paid within, he says, the next 30 days, but I said maybe we should set it maybe 60 days. But with his term coming up, I would just ask that he be discharged from probation, and if there's any civil any costs that remain, that he can be collected civilly after this point. And I informed him that, you know, he seems to be committed to getting this paid, and he understands the court, you know, do further action and bring him back to court even after he's off probation. So, you know, with his date approaching, I would just ask that he be discharged from probation
Today.
Well, on the, yeah, I would just say, I mean, the 15th is his 2-year date. That's next week, but
Okay.
so however the court decides.
All right, are you asking the court to discharge him unsuccessfully?
No, Judge, I think successful discharge is appropriate.
All right, okay. All right, so I guess the way I'd like to proceed, number one, the court will waive that attorney fee and the court costs in this case. If Mr. Trush, if you can provide to the courts a documentation of the medical expenses. Mr. Roden, you need to get that to show that was that your tax return was garnished to pay medical expenses.
Absolutely.
And then the court will allow the successful discharge on the 15th. How much are you going to be able to pay today?
$20 to $30 maybe.
Okay. Can you make another payment prior to the 15th?
I'd have to look at the calendar on when my next pay date is, but I get paid next week, so
How much?
probably another 200 plus.
200? Are you sure about that?
Yes, absolutely.
Okay, so I'm gonna order that the payment be made today that you indicated, and that I'll give you till the end of the month, till April 30th to pay that other 200.
Okay.
And then whatever's remaining we'll reserve for further enforcement.
Okay.
Okay, do you have any questions, Mr. Rowe?
No, Your Honor, I don't.
Thank you, that's all for today.
Thank you.
Just make sure you stay in touch with Mr. McDowell about those. Okay. Are we ready on Mr. Poirier's matter?
We are.
Mr. Poirier, if you can come forward to the podium, please, we'll go on the record. People versus Poirier, this is file number 25-5471. The record should reflect that Mr. Poirier is present here in the courtroom today. Time set for sentencing in this matter. Or did you have a chance to go through the pre-sentence report and talk to Mr. Trush about that? Any additions, deletions, or corrections?
Your Honor, the jail credit will need to be updated at 112, but
136.
anyway, Mr. McFaul is much better at calculating it than I am. I'm always wrong.
So we'll correct the jail credit to 136 days. Any other additions, deletions, or corrections?
No,
Do you have any challenges to this point?
no,
Ms. Cope, do people have any additions, deletions, or corrections?
No,
Do you have any challenges to scoring?
no.
Do you have any victims that wish to address the court today?
It is my understanding that the victims are attending but do not want to speak today. They've already submitted a statement.
And anything that you wanted to gate by way of allocation.
Your Honor, this case has been very difficult. The victims in this case, when it started, probably had more contact with me personally than any that I can remember. They talked to my victim advocate and wanted to come in and speak directly to me. They had several meetings with me. They came in and discussed this case with me, and I talked to them on the phone several times. They told me at the beginning of this case that they thought their son was going to kill them. And they told me that numerous times. They were very concerned. He then went out to the property to get the trailer with the police. They contacted me and discussed that. They were very concerned about their health and well-being. They talked about leaving their home. As the case progressed, they then decided that they didn't want to go forward with the case and it should be dismissed. This is not the first time I've dealt with them in this situation. We had a case a couple of years ago with domestic violence. The same situation happened. It wasn't as severe, and it had been dismissed for mental health. Mr. Poirier has a long history of mental health. He's 38 years old, but he has a juvenile record, 10 misdemeanors, 8 felonies. He has a very long assaultive history. He definitely has mental health issues, but he does not address those. His parents were the people who told me at the beginning of the case that he had quit going to all of his mental health treatment and he had made that choice himself. So we are stuck with a situation where the recommendation, frankly, is probably not going to work. Putting somebody in for 12 months with no time over their head just doesn't work. I think the recommendation would be better crafted to be a prison sentence that would allow him to get out with a mental health hold, which is similar to the prison sentence he just got out on, and would offer him much more services for his mental health, as well as when he got released, he would have much more mental health oversight. I spoke to Mr. McFauld about the services that would be available each way, and he would have more services if he went to prison. His guidelines are 10 to 23 months. Based on his criminal history, I don't see anywhere where he would be at the bottom end of the guidelines. Frankly, he's probably closer to the top end. I understand he has mental health issues and that has played into this, but I would ask the court to sentence him in the middle to towards the top end. Thank you.
Thank you, Your Honor. The recommendation here would contemplate a county jail sentence. So to an extent, I agree with the prosecutor, which is to say, the idea of putting him in the county jail for a year, having him released on probation following the year in the county jail, with the court really kind of putting itself in a position of going to the extreme sanction of MDOC because all the county jail availability has been used up. I certainly can understand the rationale there and would tend to agree that I don't think that that's the best option. I think that puts the court in a position where the court has fewer options and fewer tools. What I think the right answer here is probably county jail up front with some held in abeyance. And obviously the court always knows that with any probationary term, if there's violations, the court has the option then to take corrective steps, which are much more significant. The court at that point would have the ability to assess what the violation is. And if that requires a county jail sanction or requires the step of an MDOC sanction. And frankly, I would probably even agree with the prosecutor insofar as if there's violations, the answer probably is MDOC. With that in mind, I don't think it can be overstated how much the mental health plays into this. And I think it's important to recognize the mental health from day one to where it is now. When I first interacted with Mr. Poirier, I think it would be an understatement to say that he was in crisis. He didn't understand what was happening. He wasn't thinking clearly. He wasn't able to articulate ideas clearly. He's been lodged for the majority of the time that this case has been pending. And while there, he's been getting treatment from the nurses and from CMH coming into the jail and assisting him. He presents today different than I think he did when he went in. So this begs the question, why would we think something different will happen if the court were to release him today or in the near future with a CMH type diversion plan, a jail diversion plan, similar to what we've provided to the court? And I think the answer is that he's going to have a different quality of care than what he was getting previously. When Mr. Poirier, in the time period leading up to these events, he was working with a psychologist. The psychologist, though, was in Grand Rapids, and all of his appointments were being done via video. They were trying to adjust his meds, but frankly, for someone with his level of needs, the idea that video visits would be sufficient is laughable. He needs someone who can be there and interact with him and see what's happening. And unfortunately, in sort of the post-COVID era, we've shifted to a lot of things being done via video that probably need more of a personal touch than that. As he's been working with CMH, they're recognizing that his medications were not right. He wasn't getting medicated at the right levels. And again, we know that when medicating someone, there's two problems that are equally bad, right? Under medicating someone is bad. Over medicating them often produces the same bad results, just in a different way. What happened with Mr. Poirier, I think, is he was being over medicated. He doesn't feel right when he's over medicated. And what does he do? He does what most people do, which isn't a smart idea, but we see people do it all the time. He self-medicates. He self-medicates with alcohol because he's trying to make himself feel right. He knows he doesn't feel right. He doesn't know how to fix it. He's not a doctor. So he starts self-medicating. We see the behavior a lot. Frankly, self-medicating with alcohol, there's very few situations, period, where alcohol makes it better. Our decision-making never gets better there. It certainly doesn't help mental health issues. I think the right approach here is to give him an opportunity to address his mental health needs. I think his parents would say, and as much as did in his dad, I should say, in the victim impact statement that was submitted, when he's on his meds and he's in his right mental state, he's a good guy. He's a productive member of the community, and he's not a danger. When his mental health isn't right, yes, he's a danger. The right way for us to deal with that sort of issue isn't to lock him up, which isn't going to help his mental health. And I recognize that that's only one piece of the puzzle here, but that's not going to improve his mental health. And when he's released in a year or 13 months or 16 months or whatever the court imposes, he's not going to be in any better position than he is now. The right approach is to punish the behavior, to monitor him, and to have the ability to react if there's a violation. And I think that a blended sentence, having some jail up front, some held in abeyance, and to allow him to engage in the community mental health diversion plan is the right response. Thank you.
Thank you, Mr. Poirier.
I agree with you 100%. I'm not a violent person, and if I've been a violent person, it's because I drank. I didn't feel right. I'm just not a violent person. If you give me a chance to be in the community, show you that I can do right.
All right, well, I mean, I read through the report, Mr. Poirier, so I'm familiar with what happened in this particular case. I did get the information from your family, the letter that was submitted, some of the information from CMH and so forth that was submitted with the report. So I've read through all those materials. I'm also familiar with your history and your background. And so I try to, and I listened very carefully to what counsel had to say, which they take very opposite positions, but I think they both agree that some continued mental health treatment is absolutely necessary. I think the question is where from the court standpoint, which is completely different from, a social work or, a mental health treatment standpoint, this we're here to deal with criminal conduct. And where the court can facilitate help with the underlying causes of that conduct, it's incumbent on the court to do that. But those resources are always going to be more limited than what you can get from the private sector. But the question here is, with what the court has within its control, where are those resources best going to come from? The prosecutor suggesting it's going to come through the state and the resources that are there. Mr. Trush is indicating that he thinks that locally there's better options. So those are kind of what I'm presented with, and they're both reasonable positions to take. So I look at both of those options, and then I also look at what has happened in the past and what happened here, and what was your behavior here. And it's clear that for whatever reason, whether you're under-medicated, over-medicated, whether you just stop taking your medications, which there are some indications in the report that that's what happened. It's clear that this incident was brought on by mental health issues combined with the use of alcohol, and I think just some underlying issues that you do have. And when I look at your past history, that's certainly borne out. This is your 6th time being charged with a domestic violence offense. You've got 2 prior charges for aggravated stalking, fleeing and eluding, resisting or obstructing, assault by strangulation. It's not like this is your first assaultive offense. You've got a long history of that going back to juvenile offenses. So, you know, I can appreciate that when things are going well, you're not a violent person, but you certainly have exhibited throughout your lifetime violent tendencies. And whether that's attributable all or in part to mental health issues or just a lack of self-control, I don't know, and I don't know that anybody does. But there certainly is plenty in your past history to suggest that you do have violent tendencies when things aren't going right. I also look at what kind of prior sentences. You had 4 prior terms as a juvenile on probation. You've had 5 prior terms as an adult on probation. And at some point, the court has to recognize that continuing to do the same thing over and over again when it's not working is not appropriate. And so for all of those reasons, I don't think probation is appropriate in this case, and I don't think a local sentence provides the best option for you going forward. And I don't think it provides the best options for the community. I think having you remain in the community, given your history of violent conduct, is dangerous. And prior attempts to supervise you in the community have not been successful because you're continuing to reoffend. So for all of those reasons, I do think a sentence at the higher end of the guidelines is appropriate. It addresses the conduct that you engaged in this case. It recognizes past failures and your past history. And I think it's a reasonable sentence. The court is going to sentence you to 23 months in the Michigan Department of Corrections to 5 years. You have credit for 136 days served. The court is going to order a Crown Victims Assessment of $130, court costs of $325, attorney fees of $350. Mr. McFeld, I'm going to assume, based on his prior sentences, he's already got DNA testing.
Can I say something, Judge? I'm the father. Can I approach?
You can stay right there and you can tell me what you'd like.
I think that he deserves a different sentence than what you're giving him. I don't think he needs to be sentenced to prison. He can be a good person. What happened with us was out of hand, but like he said, it was an alcohol and everything. He can do right if he's on the right legs. He really can. I don't feel a fear from him when he's normal like that. You know, he like you said, he self-mediced himself. And I think he deserves a break in society and do what he has to do. He can do that. He stays focused. I really think he deserves that. Prison's incarceration is not going to do any good. He's been there before. They didn't turn out good. They almost killed him down there. He almost died. The same thing's going to happen again. It doesn't do no good to lock him up. You don't get no help down. They lock the key, throw you away, they do nothing. Don't help. Out here, you can get more help, what he needs, he has mental issues. That's what needs to be addressed, okay? That's it.
Thank you, I appreciate your opinion.
Nope.
I'm sure he's had DNA testing, Judge. We're kind of in, we're kind of not understanding fully if we're supposed to recommend that on every case or not. We've had kind of different opinions on that, so.
A $68 state cost. You do have the ability to seek an appeal of this sentence, Mr. Foyer or Mr. Trush. Do you have an acknowledgement of the appellate rights, Mr. Foyer?
I'll go over it with him right now. I have that for the
Thank you. Do you need to speak with Mr. James or? I think we need to take a break, Steve. We need to take a break.
It's right there.
I know, but are you all set with?
Yeah, I'm all set.
All right, Mr. James, if you can come forward up to the podium, please. We'll go on the record in versus Eric James, file number 255484. Record should reflect Mr. James is present here in the courtroom today. We could have counsel put your hands
Sierra Coke on behalf of the people.
Thank you, Your Honor. Jason Thompson on behalf of defendant Eric James.
This is the date and time set for sentencing. Mr. James, have you had an opportunity to go through the pre-sentence report and talk to Mr. Thompson about that?
Yes, sir.
Mr. Thompson, are there any additions, deletions, or corrections to that report?
Your Honor, the first thing is I know Mr. James, I know we've adjourned this twice. Mr. James would ask the court if they would consider adjourning it again, and it's because of that Montmorency trial. It's now pending at the end of the month. We had originally adjourned it, it was pending in March. Through no fault of Mr. James, that trial got rescheduled the way that happens. He just doesn't want to have to go to MDOC, have that interfere with his trial preparation and have isolation possibly interfere with his trial attendance. So that's the basis for the hearing, Mr. Honor.
Let's go.
Your Honor, I would ask the court to go forward with sentencing. MDOC will work with the writ. I frankly don't know when it's going to go. We've already adjourned this to allow for that to happen. And I don't know if the trial is going to go, but we can let the Montmorency prosecutor know right away that where he's at, and they can do the writ to follow.
Yeah, Mr. James, I appreciate the request, but adjourning this is just delaying this case. I don't know when your other case is going to go to trial, but we need to proceed with this file here today. So, Mr. Thompson, with that, are there any additions, deletions, or corrections?
No, Your Honor.
Are there any challenges to the scoring of the guidelines?
No, Your Honor.
Let's hope that people have any additions, deletions, or corrections.
I think the jail credit needs to be updated. I think it's 192 days.
Yes.
Thank you. Any other corrections?
No, Your Honor.
And any challenges to the scoring?
No, Your Honor.
Do you have anything for elocution today?
Your Honor, when you read this PSI, it's sort of hard to take into account how crazy this case actually was when you watch the body camera. I mean, I watch a lot of body camera footage and dash cam footage from officers, and this is one of the craziest ones I've ever seen. When Mr. James turned off of the main road in Grayling, right next to the Little Caesars, he lost control of his vehicle, jumped the rocks there, and flipped his vehicle in the Little Caesars like parking lot area, that little green area there. The fact that somebody didn't get injured or killed is crazy. I mean, his car was totally airborne and flipped in the air. It looked like something off of Dukes of Hazzard. It was so crazy to watch and so dangerous. Mr. James apparently left Fairview. There was apparently a BOL in Oscoda County for him. And then somebody called here because of his dangerous driving. He was driving 70 miles an hour in a 30 miles an hour zone in town. He fled from the police. He was a .214. When you read his recap of what happened in the PSI, he says, well, he was over life. Frankly, the fact they didn't take somebody else's life and make them over life against their will is impressive. His guidelines are high because he's 44 years old. He was on bond at the time. He has 15 misdemeanors, 11 felonies. He has a long, crazy criminal history. He has definitely earned the top end of the guidelines. He is a danger to himself and to others. And I'm glad that we're not sitting here today on a different type of charge with somebody having been killed. Thank you.
Mr. Thompson.
Your Honor, I'd certainly agree. It's a bit of a miracle that nobody got hurt that day. And I'm very thankful for that. I'm very thankful that Mr. James was able to come out of that. And as bad as that scene was, and as dangerous as that scene was today, I think that's a good encapsulation of what was happening in Mr. James' mind. Prosecutor referred to his statement. The court reviewed a competency evaluation that described Mr. James' struggles with mental health. And unfortunately, that day he was off his medication and it was a dangerous, chaotic situation in his mind. And he did have thoughts of hurting himself. And so just on a human level, I'm just very glad that since I've gotten to know Mr. James, that he is in a different place now, that he is not actively in that mental state where he wants to hurt himself, and actively in that mental state where his schizophrenia is, bombarding his brain with those negative thoughts and feelings. And he does have a new lease on life and a new outlook on life, Your Honor. And I think that's on a human level very good for Mr. James. I'm very good for society. Obviously, this was dangerous conduct on this day. It was dangerous to Mr. James probably more than anyone. And it is a bit of a miracle he survived that day, and he survived without any serious injuries. And then again, to the point where he's now much mentally healthier than he was before. This was clearly born out of and caused by his mental health struggles, born out of and caused by the fact he wasn't being medicated at that time. He was trying to escape bad influences downstate. He moved up to try to get a new start, and he did not. He struggled with reestablishing his mental health care and his prescriptions. And ultimately, he's the individual who's responsible for that. He's not trying to say anybody else is responsible. He knows that he did wrong that day and he created a dangerous situation. Having said that, Your Honor, I think this case really boils down to whether he's on his medication, whether he's in a good place, and when he is. Again, I've got to know that he's a different person than he was that day. So I'd ask the court to consider a sentence in the middle of the guidelines. I think this really was kind of a continuation of what may have started in Montmorency in terms of him not being at his best. So I'd ask the court to sentence concurrently and in the middle of the guidelines. Thank you.
Mr. James, anything you wanted to say?
I apologize. Apologize to Grant County, through my actions. Can't justify it for anything.
James, I did read through the report, so I'm familiar with what happened in this particular case. There's also a lot of information in there about you and your circumstances and your background and so forth. Much like Mr. Poirier before you, I think there's certainly a mental health component here to your actions, not just in this case, but throughout your lifetime. I think it's clearly something that you've been battling. And unfortunately, it leads you to do things that puts other people in danger. In this case, you certainly did. And that's what the lawyers have to say. It's amazing that you yourself weren't seriously injured or killed. And it's amazing to me that during that travel from Fairview, which is a significant distance from here, throughout that entire journey that you didn't encounter another vehicle or hurt or harm someone else. In the position that you were in, doing what you're doing. Not to mention the danger that put the police in throughout the course of the incident as well. So, you know, your behavior in this circumstance, coupled with your prior record, which Ms. Polk alluded to, leads me to conclude that certainly a sentence at the higher end of the guidelines is appropriate. The recommendation is for 36-month sentence. The guidelines call for up to a 47-month sentence. I think that's a reasonable recommendation. I think that it adequately accounts for your behavior in this case, as well as your past record. So I am going to follow that recommendation. Court is going to sentence you to 36 months to 20 years in the Michigan Department of Corrections as to count one. You have, and count two, I'm sorry. You do have 192 days credit. The court will order $130 in state costs, $325 in court costs, $350 in attorney fees. Sorry, 130 crime victims assessment, 136 state costs. As to count three, which is operating while intoxicated, 93 days in the Crawford County Jail with credit for 192 days served. Restitution in the amount of $150 payable to the Crawford County clerk to be dispersed to the prosecutor's office. $100 fine, $332.98 for the OUIL testing fee. State costs, those sentences to run concurrent to each other. You have the ability to seek an appeal of the sentence, Mr. James. Mr. Thompson, you provided the account of those rights to Mr. James.
Judge, I feel like you said 20 years on that, on count one. I think it was, maybe I'm hearing things, but it should be 7 years,
I did,
6
that must
months.
be a typo in the report.
Okay.
7 years, 6 months.
All right, thank you.
That's your max. Is that correct? Your minutes, 36.
I said 3 years to 20 years. It's 3 years to 7 years, 6 months.
These are your copies if you wish to file an appeal. You would use these documents, that's both how you request it. An attorney hands you file an appeal. You have 14 days for the first deadline. So if you want to appeal, get those out within 14 days. Just fill out this form. You can kite it out and it will mail it to the correct address.
So don't find and Crawford will pay it when I get out.
Well, they're payable now. They start accruing late fees in 56 days. Obviously, you know, you don't have the ability to pay.
Thank you.
Thanks.
Mr. Chairman, with you was ready on his case.
How's that, Mr. Scarborough?
No, I don't have Mr. Scarborough, Judge, Mr. Thompson, if it's wrong in the doc, it's always listed me, but
Okay.
it's just, Mr. Thompson has Mr. Scarborough, I have Mr. Phillips.
Mr. Phillips. Ms. Pope, do you have any objection to proceeding with that case now? Quite a bit early.
No.
Okay, come on. Thank you, Judge.
So address one thing.
You want us to wait backwards?
No.
Okay.
Ma'am, that's just joined us on Zoom. Can you unmute, please? Tell me your name, please.
Caswell?
Caswell?
Yeah.
Okay. We're not quite ready for your case, but if you can just remain on the line, please.
Thank you.
Okay. Let's go on the record in People versus Anthony Phillips. This is file number 265522. If I could have counsel for your
Sierra Coke on behalf of the people.
Thank you, Honor. Ravi Mertz, and appearing on behalf of Mr. Phillips. He's.
This is the date set for sentencing in this matter. Mr. Phillips, if you had an opportunity to go through the pre-sentence report and talk to Mr. Grimworthy about that.
Yes.
Murphy, I did receive your sentencing memorandum. I had a chance to review that
Thank you.
prior to the hearing today, as well as the support letters by Jessica and Alyssa Smith. So I did have a chance to review all those things prior to the hearing. Do you have any other additions, deletions, or corrections to the PSI?
No, Your Honor. And I believe the guidelines are accurately scored for that 0 to 11 months.
Thank you. Ms. Cope, do people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to this one?
No.
Anything on behalf of the people for allocation today?
Your Honor, I struggle when somebody's behavior causes this much damage and puts this many people in danger to think that they will get no jail time at all. He was driving a vehicle at a .244. I believe the police report says he got up to speeds of 90 to 100 miles an hour. He crashed his vehicle. He caused substantial damage to the victim in this case, who had a brand new tractor, and took the tractor out. It was lucky that that tractor was, I think, covered by insurance. But anyway, we had multiple calls about the amount of damage to that, over $10,000 tractor. I understand that Mr. Phillips is young. He has, only 2 misdemeanors and no juvenile record, but he didn't just make a poor choice to drink and drive. He made a poor choice to drink and drive and then run from the police and then end up in a very bad crash and then cause somebody substantial harm and damage to their life because of his actions. So I do think that some jail, even if it's only, 15 days, is appropriate. I don't think that somebody who takes off from the police and does 100 miles an hour on a dirt road in town should get no jail at all. Thank you.
Mr. Governor.
Thank you, Your Honor. Mr. Phillips is 21 years of age, very minimal prior criminal history and very low guidelines. Mr. Phillips is employed. He also has great skills of working as a mechanic. He gets to work doing some mobile mechanic work, good support with his girlfriend and his mother. And I think Mr. Phillips is the first one to tell you, and when I first was assigned to this case, he was terribly sorry as to what happened. This is something out of character. This is not something that he does. This is not something he engages in. And since then, he's been doing well on bond. He immediately went and got a substance assessment. He's working towards outpatient counseling, working towards the recommendations in the assessment to finish the alcohol highway safety class, the victim impact panel class, all to understand that this is just conduct that he can't engage in again in the future. And I think he also understood that the minute he was arraigned and read the police report and really got an insight of a lot of other details that he really doesn't remember because he was drunk at a high blood alcohol content. He's certainly very apologetic to the victim. I know Mr. Thompson represents the victim, at least in the civil matters. We've extended our sincere apologies to the victim in this matter. This is certainly out of context in how Mr. Phillips conducts his life and functions. So he's terribly sorry for what happened. I think the recommendation is well within reason. It's 60 days to be held in abeyance to give Mr. Phillips, again, being young, taking the steps that he has to prove to the court that he can comply with probation. Probationary period. He can prove to the court that he can comply and do the things he's supposed to do. If he doesn't, he has guidelines of 0 to 11 months. The court can certainly impose 60 days or more. But at this point, I don't believe that when somebody's taking the steps, they're remorseful for what happened and immediately taking steps to curb those behaviors, that the immediate punitive sanction would do any benefit, but rather than hold that on top of his head, essentially, to make sure he continues to do those things. If Mr. Phillips unilaterally didn't do those things, I would agree that a short jail sentence may send that message, but he's taken those steps to show the court that he is able to comply with court orders. He's not going to engage in this behavior. He's done well on bond. He's going to do those things. So those reasons that I asked to adopt the recommendation. Thank you.
Is there anything you wanted to say today?
No, Your Honor.
All right, I did read through the report, so I'm familiar with the circumstances that are before the court today. Also, there's a lot of information in that report about you generally and your background, your circumstances. Take all of that into consideration along with what the lawyers had to say. There certainly are some some positives to your situation in terms of rehabilitation. One of the things that the court looks at is what are the prospects that this person is going to repeat this behavior. You're a young man, you don't have any significant prior history, you got a couple of minor misdemeanors in there, but nothing certainly rising to the level of this kind of dangerous conduct. So those things give me some reason to believe that you can move on from this and not repeat this kind of behavior and use this as a learning experience. And for those reasons, I do think that the probation is appropriate. It's going to give you an opportunity to show through the probationary period that this was lapse in judgment and not going to repeat. And it provides us with some supervision of you so that the community can feel a little safer knowing that you're being watched and tested, make sure that you're not left to your own devices here. As you move forward for a period of time. There's negatives though. Drunk driving, as dangerous as it is not that unusual of an offense. Lots of people have a little too much, get behind the wheel when they shouldn't have. Not everybody creates the kind of danger that you created. And you really did put yourself in a great deal of danger. You're lucky to be standing here today and not seriously injured or permanently injured. From a community standpoint, it's a lucky thing that nobody else was harmed or killed as a result of your actions, and that the only thing that was done was property damages, as that was. And so I think that that does deserve a degree of punishment. And for somebody such as yourself, who has never really been in a jail environment, I think a short jail sentence can make a big impact on you and can make you understand that this is just absolutely unacceptable behavior. I think I agree with Ms. Koch. I think it sends a wrong message to the community that if somebody's going to create this kind of situation, that there isn't a punishment to be paid. And so I think a combination of probation along with a jail sentence is absolutely appropriate here to address the level of the seriousness of the danger that we created during the course of this incident. And getting behind the wheel of the vehicle with the kind of blood alcohol content you had at that time. So for those reasons, as to the operating while intoxicated offense, court is going to order restitution in the amount of $114.68. That's payable to the Crawford County Clerk to be dispersed to the Sheriff's Department. A fine of $100 and a $50 state cost. As to the fleeing and eluding fourth degree, the court is going to order that you be placed on probation.
Oh, I was just asking if there was anything in his pocket. Oh.
The court's going to order that you be placed on probation for a period of 24 months. The court is going to adopt as the conditions of your probation all the terms and conditions listed in the report. The court is going to order 90 days in the Crawford County Jail. You have credit for 1 day served. The court's going to order that you serve 30 days of that up front. The court will hold the remaining 60 days in advance. Crime victims assessment of $130, court costs of $325, attorney fees of $350, DNA testing fee of $60, and a $68 state cost. Court will order that you pay a $30 per month supervision while you're on probation. You have the ability to speak and go off this sentence. You can provide an account.
I do have his appellate paperwork. We didn't have the paperwork, so I just printed one and hand wrote the information on that.
Thank you. And Mr. Phillips, you're the account.
And Judge, he does get the 1 day credit against the 30 days, correct?
Correct.
Thank you.
You're right, right? Got this.
I'll tell Steve, put me on the,
Yep, me too.
put money on there. Thank you, Tiger Hunter.
Thank you.
Yeah, we'll go on. Let's get it over your phone.
All right, Mr. Garfield, are you able to hear me okay?
Yes, I can, Judge.
All right, we'll go on the record in People versus Caswell. This is file number 265533. The record should reflect that Ms. Caswell, as well as her counsel, Mr. Garfield, are appearing by Zoom today by prior approval of the court. We have Ms. Koch, the prosecutor, present here in the courtroom today. This is set for a status conference in this case this morning. Mr. Garfield, can you tell me the status of this case? And have you had any discussions with the prosecutor?
Yes, Your Honor. We've had discussions. Currently, I have been in contact with Detective Capadlo, and we've had a struggle trying to get a date because of ice storm or just different things. But we do have a meeting set up for next Wednesday, and we're going to go over a checklist of all the different itemized things on a list that we have explanations for. And I believe it's going to take us 2 meetings, maybe 3, and a little bit of additional discovery as we get more into it. But we found a way to whittle that list down a lot. So I'm thinking we'll need to do another 30 days, 45 days continuance.
Okay, Ms. Koch.
He's correct. I've been in contact with the detective and defense counsel. They're providing some additional documentation. This is a financial crime, so there's substantial documentation on both sides of the case. Detective Capadlo is working on that, so a 60-day adjournment would be appropriate. At that time, we can determine whether or not we're moving towards a resolution or moving towards jury trial.
Okay, so based on what both counsel has said and my review of the file, I do think extra time is appropriate in this case, given the nature of the allegations and the need to really go through what sounds like a lot of financial records. So the court will set this for another status conference in 60 days. And we'll see where we're at that point. If it looks like we're moving towards resolution, then we can address it that way, and if not, then I can docket it, at least get it on the trial calendar so that everybody has a date to work towards. Do you have any objection to that, Mr. Garfield?
No, I do not, Your Honor. I appreciate it, and I appreciate the Zoom today.
Okay, certainly. Ms. Koch, anything further from your side today?
No.
Ms. Caswell, do you have any questions about how we're going to proceed with your case?
No, I understand. Thank you.
Okay, so Ms. Caswell, just make sure that you stay in touch with your attorney, Mr. Garfield, so that he can help you proceed with your case. And the court will send out the notice of date and time for that next hearing in 60 days. Again, Mr. Garfield, if you make a request ahead of time, I don't have an objection to you and your client's appearance by video as well.
All right, great, Judge Mertz. I appreciate that.
Okay, thank you. That's all for today, and you're both free to disconnect at this time.
Thank you.
Mr. Thompson, are you ready with your next case?
Is that Mr. Quack or Mr. Trump?
So we could take either one at this time, Joe, when you're ready.
So Mr. Quack is here.
Okay, Mr. Quack, yeah, okay. Mr. Quack, you want to come forward, please? Right to the podium, please. Thank you. This is file number 265524.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Jason Thompson on behalf of the defendant, Mark Quack. Your Honor, I spoke to the prosecutor just yesterday. She was out last week. We had a busy court day on Monday, but I spoke to her, and I believe there's an agreement to a new offer. I don't know if it's been reduced to writing, but an attempted resisting and obstructing one count to resolve the case. That'd be a 1-year maximum. Is that a correct statement of the offer?
It is.
Okay. And Mr. Quack intends to accept that plea offer, Your Honor.
Okay, Mr. Quack, have you had an adequate opportunity to speak with Mr. Thompson?
Yes.
Yes. Is that how you wanted to proceed?
Yes, sir.
You raise your right hand for Do solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Quack, are you currently on any kind of probation or parole?
No, I'm not.
And you understand that by pleading guilty to resisting or obstructing as an attempt, that the maximum possible penalty you can face would be up to 1 year and or $1,000 fine?
Yes, sir.
With that in mind, what is your plea to that charge today? Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf here at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you want it. You understand all those rights?
Yes, sir.
You understand that you're going to be giving up and waiving all of those rights by pleading guilty.
Yes, sir.
Anybody threatened you with anything to get
No,
you?
sir.
Has anybody promised you anything other than what we said here in court?
No, sir.
Is it your own free choice to enter this plea?
Yes, sir.
Are you pleading guilty to this charge because you are actually guilty?
Yes, sir.
The information I have indicates this happened back on November 24th of 2025. Is that the correct time?
Yes.
On that date, were you here in Crawford County?
Yes, sir.
And did you come into contact with Deputy Clark from the Crawford County Sheriff's Department at some point?
Yes, sir.
Is that person wearing their uniform?
Yes, sir.
Did you know that that person was there performing their duties as a police officer?
Not at first, sir.
What did you think they were there?
I was walking and I hadn't heard them until somebody grabbed me. And then I kind of jerked away from them and then I realized it was them and I calmed down. I didn't know who was grabbing on me from behind.
Okay. So where did this happen at?
I was walking basically the snowmobile trails trying to get down the whole lake to a doctor and I had gotten lost and turned around and I came out on, I want to say southbound 75 where the 127 split off is at. And I had crossed the bridge and I was going to walk back across 127 because I knew the areas. I live right down the street. So I kind of, okay, I'm close to home. This is where I had come out of the woods earlier. I kind of knew where I was at. So I knew I could get home from that point. And as I was waiting for cars to pass me to cross back over, I had got grabbed by the officers.
Okay. So at some point you realized they were police officers.
Yes.
And they were interacting with you because you're trying to cross the freeway.
Yes.
Right, and they give you some type of commands that you didn't follow.
We were talking and I had told them I hadn't been on my medication in 48 hours. I was having real bad, like, I was going through a, infection. And I was told not to take them to try to make it to the doctor because it was hiding the.
Well, I don't want to get into all of that.
Well,
I don't want you to
I
divulge
told
a bunch
my-
of information. about
my
your
arms kept cramping up and they had both of my wrists and I told them I was my arms were about to cramp up and when they cramped up, I guess they took it as I was trying to pull away from them or something, but I was trying to explain to them I'm cramping up, I can't stop it. And then they pinned me to the ground.
Mr. Thompson, I don't know if you have other facts about what happened during this. That sounds like Mr. Buck is saying that it was involuntary. So I'm not sure that on a right basis. Maybe there are other facts though that.
I understand the court's concern. Mr. Quack, did you refuse to follow a lawful command of a police officer?
No, I didn't.
Okay, so you're not guilty of the offense.
I followed everything that they told me.
All right, Your Honor, I don't believe the court can accept the plea at this point.
Yeah, Ms. Cope, do you have any other facts that would?
I mean, the facts from that Mr. Quack gave are significantly different than the facts in the police report. So, but based on his statements, I do not think he would be guilty.
happened?
That he was given several loud commands to stop walking away. He announced announced sheriff's office continued to make several loud comments for him to stop. He did not respond to the commands, started walking away faster. He not quite to a sprint, but significantly faster. They traveled through a thick wooded area. The officers were jogging to catch up to him. He continued to go away from them. They caught up to him and grabbed his right arm. He began pulling away from them and telling them to let go of him. He continued to pull away. At this point, Deputy Minnick reached and Quack grabbed his left arm. He attempted to place him in handcuffs. He continued to pull away. He attempted to put his hands in his sweatshirt pocket. And then eventually they were able to put him under control. After they put him under control, he was making statements that he was trying to follow the commands.
So it sounds like the officers are saying they were yelling to you that they were police officers and you were starting to jog away and they had to run after you. You're saying that didn't happen?
No, if they were yelling at me, I couldn't hear them. I was on a noisy highway. And all I did was I crossed over the bridge, and when I seen the 127 split off, I jumped the guardrail, I walked on, I walked up, there was cars coming, so if I was running from them, why would I stop and wait for the cars to pass?
Okay. All right, well, I mean, if you're saying that none of what Ms. Coke just described happened, then the lawyers are right. I can't find you guilty of resisting a police officer. You didn't resist.
I understand that, I just, I know these guys don't like me very well, so I just would rather take one charge than three.
Well, but yeah,
I understand. Do you want to discuss this in private in terms of what we want to do moving forward? Okay.
all right. Let's just take a break and then let us know how you understand.
Thank you.
Okay, sir, are you, Evan Sherbet?
Yes, I am.
Okay. All right, we're on the record now in People versus Sherbet. This is file number 255482. The record should reflect Mr. Sherbet appearing today by video from Delta County Jail. If I could have both counsel for your appearance.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Jason Thompson on behalf of defendant Evan Sherbet.
Thank you. Mr. Sherbet, this is the date and time set for sentencing hearing in your case. Have you had an opportunity to go through the pre-sentence report with Mr. Thompson and speak with him about that?
Yes, I have, Your Honor.
Mr. Thompson, are there any additions, deletions, or corrections to that?
Just as an addition, Your Honor, I don't know if this was previously submitted, but if I could approach. Thank you. Back when we were first planning the sentencing for Mr. Sherbet, we had talked about him attending this rehabilitation program in Wisconsin. It turns out that's where he was on February 5th. He has several cases and there were some issues with him being in contact. So that is what occurred on February 5th, Your Honor.
Okay, thank you. Any other additions, deletions, or corrections?
No, Your Honor.
And do we need to update any jail credit on this? It's been a while since it's taken back in November. And I don't know that he's entitled to any credit on this case. Not sure what.
Where is he? Yeah, I don't think, he's posted bond. I don't think his bond has ever been revoked.
Yeah, I believe he's a Delta, but I believe he's awaiting sentencing. Is that correct, Mr. Sherbet? You're scheduled to be sentenced in May in Delta?
Yes, they did report date pretty far out, yes.
Okay.
So if his bond is not canceled, I would agree with Mr. McFall that would actually address a different point. I wanted to inquire about the status of his bond, but if it is not canceled, then yes, no credit.
Okay.
Except for the 4 days that's already on the GSI.
Sure. And do you have any challenges to the scoring, Mr. Thompson?
I do not.
Ms. Pope, do the people have any additions, deletions, or corrections?
No,
Any challenges to the scoring?
no.
Anything on behalf of the people for allocation today?
Mr. Sherbet has, this has been one of the stranger files we've had. I think when it started, he was in Livingston County Jail. And then we had a sentencing scheduled and he was in the Marquette County ICU. And then I had a note that he might be in a Milwaukee facility. And then I got then we did a bench warrant for failure to appear. Then we got a note that he was in Delta County Jail. And then, we have today's note that he was at some point in the Milwaukee facility. He has some medical issues going on. I mean, he has all kinds of things. He doesn't appear to be taking care of any of them. And only appears when he ends up being lodged. The recommendation is 60 days in jail with the 4 days credit. It's, I think, given what's gone on this file and the charge, that it's appropriate. Thank you.
Thank you, Mr. Thompson.
Your Honor, I do agree this is an appropriate recommendation. I do understand Mr. Trombley, has himself involved in several court cases. I think Ms. Cope referred to him not taking care of certain things. I think, unfortunately, Mr. Trombley is an individual who served our country.
Mr. Sherbet.
I'm sorry, Mr. Sherbet. Thank you, Your Honor. Thank you. Unfortunately, Mr. Sherbet is an individual who served our country. He is a veteran. He has combat experience. He has PTSD from that combat. And I think, unfortunately, there are times when he just quite frankly doesn't take care of himself in a way that's very deleterious to his health and that's deleterious to his legal status. So Mr. Sherbet is, again, someone who has served our country, came by these conditions, in that way. I think we should continue to give him the latitude to try to learn how to take care of himself, how to address this, and I think the recommendation is appropriate. Thank you.
Thank you, Mr. Sherbet. Was there anything you wanted to state today?
No, just, I agree with everything they say, everything. I do need to take care of myself a little bit better, especially with my mental health. I got my liver disease and stuff like that, but, yes, I went to the when I was in the rehab, I missed the court date I was supposed to be in person for, and that's why I came back here. And then that's why I'm in jail. So I just want to take care of everything I take care of, get all this past me and everything like that. And that's about it.
All right, thank you. Mr. Sherbet, I did read through the pre-sentence report, so I'm familiar with the circumstances of the offense in this case, as well as just generally your background and your history, including your prior criminal history and your current issues. And so, you know, looking at the offense in and of itself, it's not a particularly severe offense. There was, it looks like, a relatively small amount of methamphetamine that was located. You know, the report reflects that you indicated that was some methamphetamine in your backpack from a number of years prior, and that you didn't know it was there. I don't really, to me, that's hard to believe. It's been my experience that people who are using methamphetamine generally don't lose track of their methamphetamine, and they don't leave amounts just laying around that they forgot about. They know exactly how much they have and where it is at all times, and they generally use it until it's gone. So I find it very dubious that this was methamphetamine that was just somehow forgotten by you in your backpack. But that being said, I think there are some reasons to mitigate the sentence here. The guidelines are 0 to 11. The recommendation is for 60 days. I think that adequately accounts for the mitigating factors here, but also addresses the wrongfulness of your conduct. So the court is going to follow that recommendation. The court is going to sentence you to 60 days in the Crawford County Jail. You do have credit for 4 days served. And the court will also order a crime victims assessment in the amount of $130, court costs of $325, attorney fees of $350, and a $68 state cost. You have the ability to seek an appeal of this sentence. If you haven't already been provided with it, you will be provided with some papers that explain to you what your appellate rights are, as well as how to request a court-appointed attorney to help you with any appeal. Your time for filing that appeal won't run until you actually receive those papers. So to the extent there is any delay, that won't prejudice you. And Mr. Thompson.
Those papers are on council table. Is the court instructing me to mail those to Mr. Sherbet to file a proof of service with the court?
Yes, please.
All right, thank you.
Mr. Sherbet, did you have any questions at all?
I just had 2 questions really quick. I want to make sure, is it going to be able to run concurrent with what I have here, or current with what I have here this time? And then also, am I able to pay the court costs and fines out of my bond? So that way I get that just taken out and taken care of.
So question number 1, yes, concurrent. Question number 2, I don't know. Unfortunately, our clerk is not here today, so I don't have the information about your bond and what was posted. I know that they generally will apply any bond to any outstanding fines and costs. But that's something that if you had questions, either yourself or through your attorney, you would need to check with the clerk's office here in Crawford County.
Okay.
Anything? Did you have any other questions?
No, I think that's it, Your Honor.
All right. Thank you. That's all for today, and the court is going to disconnect at this time.
Thank you.
So the Wexford, you're on.
It's going to be Scarboro.
Yes.
Did you figure it for as a duty attorney? It's a
Yes.
arraignment.
No, I'm sorry, Judge. Is it arraignment?
I think
This case has been so confusing.
I
think it's actually a hearing. It looks like he was arraigned back in February of this year. Oh, maybe not.
Jen said.
Maybe not. Yeah, you're right. I'm looking at John's notes. I can see what he said now.
Oh.
Great, it's hard to read. Sorry.
Can you hear me?
Yes, I can. Can you hear me?
Yes, I don't know if you can I can't see you. I don't know if you can turn the camera on. Is this
There we go.
Yes.
Thank you. You're Mr. Scarboro?
Yes, I am.
Okay. All right, we're on the record in People versus Scarboro. This is file number 235253. The record should reflect Mr. Scarborough is present today by video from Wexford County Jail. Mr. Scarborough, we're on the record here in Crawford County for an arraignment on some alleged probation violations. Did you ever receive a copy of the alleged probation violations?
I did not receive a copy of the violations. No, I just received the paperwork for the court hearings.
Okay. So I'm gonna. Can you say that again?
Just the papers that said I had court in March and the ones for this court hearing right now.
Okay. So I'm going to go through a few things with regard to your rights, and then I'm also going to read to you what the alleged violations are, okay?
Yep.
All right. So first of all, with regard to the alleged violations, they're all technical violations. Count one, that you violated condition number 3 of your probation in that you failed to report to your probation officer on or about January 14th of 2026. A violation of your probation in that you have not made payments towards your fines and costs and other financial assessments. A violation of in that you have not paid restitution as owed of $129, fines of $500, that you have failed to complete any service, and that you have failed to complete outpatient substance abuse treatments. Do you understand what's being alleged?
Yes, Your Honor.
Okay. So you do have the right to have a hearing as to whether or not you violated your probation as alleged. You also have the right to have a lawyer present at any subsequent proceedings. If you can't afford a lawyer, one would be appointed for you. We have here in the courtroom today, Mr. Thompson. He's one of our court-appointed attorneys. He's here for purposes of arraignment. If you wanted to speak with him, then I would be willing to take a break from this hearing and give you an opportunity to speak with him if you wanted to do that.
I had spoken to Mr. Thompson once before we were supposed to have court this last time.
Okay. Did you want to speak with him here today about these violations?
Your Honor, based on our discussion, I believe there was a plea of, a recommendation from Mr. McFarland. If he could say on the record, I believe Mr. Scarborough intended to accept that.
Okay, Mr. McFarland.
This has been a complicated case, judges. Mr. Scarborough's been kind of in and out of jail, has been in different situations. I would just ask if you plead guilty to count 1 of the violation, dismiss the remaining counts. It's a technical violation that I would recommend additional 15 days jail and discharge from probation.
Yes,
Okay,
Your Honor.
were you able to hear that, Mr. Scarborough?
Yes, Your Honor.
Okay. Did you want to talk to Mr. Thompson about that, or did you want to accept that offer?
I will accept that offer.
Okay. All right, can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. You can lower your hand. Mr. Scarborough, has anybody threatened you with anything to get you to plead guilty to this violation?
They have not, no.
Has anybody promised you anything other than Mr. McFarland just indicated here on the record?
Nope.
And you understand that by pleading guilty, you're going to be giving up your right to have a hearing as to whether or not you violated your probation?
Yes, Your Honor.
Are you pleading guilty to this violation because you did violate your probation?
Yes, I did.
All right, were you on probation on or about January 14th of 2026?
Yes, Your Honor.
Were you aware that one of the conditions of your probation was that you were to report to your agent as ordered?
Yes, Your Honor.
Did you fail to report to your agent on or about that date?
Yes, I did.
All right, the court finds the plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that Mr. Scarborough did violate his probation, and the court will accept the guilty plea. Mr. McFell, other than what you've already stated, did you have anything else you wanted to state in terms of sentencing?
No, Judge.
Mr. Thompson?
I believe it's an appropriate recommendation, Your
Mr. Scarborough, was there anything that you wanted to say before the court passes sentence today?
No, Your Honor.
All right. So, Mr. Scarborough, I am familiar with your case. I did have a chance to review your file prior to the hearing today. And I do think the recommendation is appropriate given the issues that you've had during your time on probation and the other issues that you have going in other jurisdictions. So I do think it's appropriate as a technical violation to sentence you to 15 days. Do we have any credit on that?
It would be an additional 15 days jail, so I would zero credit.
All right, an additional 15 days of jail with no credit as to that sentence. The court will preserve any outstanding fines and costs. The court will discharge you unsuccessfully from your probation. So, Mr. Scarborough, you'll no longer be on probation here in Crawford County. However, you will still be responsible for payments of the restitution and any outstanding fines and costs.
Okay.
The court will order that your sentence be served concurrent with any other sentence you're currently serving. You do have the ability to seek an appeal of this sentence. I doubt we have Mr. Scarborough's rights there. Oh, okay. So, Mr. Scarborough, Mr. Thompson is going to mail your appellate rights to you. That's going to explain to you how to appeal the sentence if you wanted to do that, as well as how to request a court-appointed attorney to help you. Your time for filing that appeal won't run until you actually receive these papers. Do you have any questions at all?
Just is my 15 days like starts today?
Correct.
Correct. Okay. That would be the only question, Your Honor.
Okay. All right. Thank you. That's all for this hearing today, and the court is disconnected this time.
Okay.
Our next hearing is set at 11:15, so we'll take a short recess. Mr. Bogler, if you could come over to the podium, please. On the record in People versus Bogler, this is file number 255500. Mr. Bogler is present here in the courtroom today. If I could have counsel put your appearances on.
Sierra Cook on behalf of the people.
Thank you, Your Honor. Jason Thompson. I'm standing in for Richard Trush, attorney of record.
This is the date and time for sentencing in this matter. Mr. Bogler, obviously, Mr. Trush is your regular attorney. Do you have any objection to Mr. Thompson being here for purposes of this hearing today?
No.
Okay. And Mr. Bogler, did you have a chance to go through the pre-sentence report?
Yeah.
Oh, you did. Okay. Mr. Thompson, are there any additions, deletions, or corrections to that report?
No, Your Honor.
And any challenges to the scoring?
No challenges, Your Honor.
Ms. Coke, do the people have any additions, deletions, or corrections?
Your Honor, it states that we have no objection to 7411 if eligible. Frankly, his criminal history that was provided to me only had 4 misdemeanors on it. It is quite clear that he is not eligible for 7411 based on his actual criminal history.
Do you have any challenges to the scoring?
No.
Anything by way of allocution on behalf of the people?
Mr. Vogler has done terrible on pretrial services. I think since this case ensued, maybe even since his plea, he's been in Wexford jail, Manistee jail. I have another note about another jail, so I'm not sure what's going on with him. He's in and out of jail everywhere. He has 9 prior felonies, multiple delivery cases, 15 prior misdemeanors, and he scores out 5 to 23. He's given multiple opportunities for rehabilitation, which he's failed at pretty miserably. He doesn't appear to have any desire whatsoever to be a law-abiding member of society in any way, shape, or form. I think the middle of the guidelines is appropriate. Thank you.
Thank you, Mr. Thompson.
Thank you, Your Honor. I do think it's an appropriate recommendation, and I think it's the kind of recommendation that perhaps Mr. Vogler could also use to take advantage of his desire that he stated to me to attend some rehabilitation, either within the court's jail sentence or within the court's probation time. He did report to me an honest desire to seek some treatment and get some help. Very tragically, apparently his son passed away from a drug overdose only about a month ago. He was very emotional when he spoke to me about it. And I think it was really significant to him and significant to how he sees, what he's going to be doing moving forward. I think for all those reasons, this is an appropriate recommendation. This is a nonviolent offense. It's fundamentally born out of addiction, Your Honor. And I know the court and everyone else in the criminal justice system struggles with how to best treat addiction and, fundamentally.
Is there anything you wanted to state for the record?
Yeah, for the record, now the jail, there are cases that are old cases that were popping up since this case here. When I was here last, I left here and went to back to Wexford, in the house with Caswell. There, when I got released there, I went down to Manistee County for child support. And I had one other case pop up in Lake County from over a year ago. I had no clue that it was going to happen. I would like a chance to get clean for it because of what happened to my son. I don't want that to happen to me. I really don't want to go back to prison. If I could get one fair shot at it, I ain't going to prove you wrong.
All right.
Your Honor, if I could just add something I neglected to mention. The PSI I have contemplates a sentencing date of 3/16 when we're so I don't know if that count needs to be updated.
Showing that he's posted his bond. Bond revoked, bond reinstated on 2/20 is the last I had.
Oh, okay. I probably just wasn't reading that correctly, Your Honor. Don't have any further comments.
57 is the correct number of cases.
The way Mr. McFaul explained it makes sense, Your Honor. Thank you.
All All right, so Mr. Bogler, I did read through the report, I'm familiar with what happened in this particular case, as well as your past history and your past record. There was a statement in here. Okay, I'm not sure how it got in here, but from Miss Kimberly Long Miller. Talking about how your substance abuse issues have affected.
How did that, Kimberly Long, how did that get into my PSI? Sure.
As soon as she submitted it to the prosecutor's office as spoke.
I don't think so, because I got it through the PSI too.
That's like mix up in paperwork. That's my first son's mother.
I'm sorry, what's
She's
that?
my oldest son's mother.
Yeah,
So I don't understand why she would be involved in my PSI.
I don't know, it was in there.
I do seriously want to go to rehab. I had funding available. I was already approved at ATS. So I just have to
Yeah,
make sure all the
Okay.
things line up.
and I definitely take that into account. I'm just saying that her letter, is something that I read, and it had information that I thought was relevant to your substance abuse issues, references to the death of your son, which I'm very sorry to hear about. It's terrible. Nobody ever wants to have that happen to their child. And so, I'm saying all of that because those are things that I take into account when trying to determine what's an appropriate sentence in this case. And I'm sure you're aware that this wasn't the most serious offense when I look at the offense variables and the scoring. They're very low, but a lot of it's based on your prior history. And you've had a lot of prior attempts at local sanctions like jail and probation. Have 7 prior times on probation, 11 prior jail sentences, and been in prison before as well. And so the prior attempts at rehabilitation have not been successful, and there's been significant prior attempts over time. And so at this point, from the court standpoint, I'm not willing to put more community resources towards that, because once you've been on probation 7 times, it doesn't make sense to continue to put you on probation when it's not working.
I was a lot younger back then. I really didn't care about my future.
Sure. Yeah,
I know.
and that's not to say that people can't change, and that people can change at any age. But what I'm saying is, I'm on behalf of the community. Or I'm not willing to bet on that anymore. You can make the decision yourself. Without waiting until you get arrested for something to do it. And you're at that point now where you're either going to spend time in prison or you're going to do what you need to do yourself to get help for yourself. But from the standpoint of the court ordering it, we're just past that point now. And so based on your past history, based on you continuing to reoffend, the court finds that a sentence, Department of Corrections sentence is appropriate in this case. And so the court is going to sentence you to 23 months to 10 years in the Michigan Department of Corrections. You have credit for 57 days served. The court's going to order a crime victim's assessment of $130, court costs of $325, attorney fees of $350, and a $68 state cost. You have the ability to seek an appeal of the sentence. Provide those rights.
I don't see those rights on the council table, Your Honor, I'm sorry.
They might be in the file. I think Ms. Medler indicated she put them in the file.
Court file?
Yes.
Oh, okay.
They're not in the court file. So we'll have to provide those to you, Mr. Bogler, but your time for filing an appeal will not run until you actually receive those papers. They will tell you how to file an appeal, a request for an appeal, as well as how to seek a court appointed attorney to help you with it. Ms. Koch, is there anything further we need to address today?
No, thank you, Your Honor.
Mr. Thompson?
Nothing further for today's record.
All right, good luck to you going forward, Mr. Roby. Okay, Ms. McGregor, were you ready on Mr. Michelle's case?
Yes, Your Honor. Could you just give me 1 second? I'm just walking out of court.
Yes.
Yes, Your Honor. Christy McGregor on behalf of the people.
This is file number 255502. Thompson, you're hearing on behalf of.
Correct.
Okay. Mr. Trush has been your attorney up till now. Do you have any objection to Mr. Thompson's hearing on behalf today?
No, sir.
Okay. This is set for, I believe, a violation hearing today.
It is set for a hearing, Your Honor. I explained to Mr. Michelle he has a right to seek an adjournment because statements on the record today could be used against him in a criminal case. So on that basis, we will be asking for the adjournment of this hearing.
All right, Ms. McGregor, do you have any objection to that?
I do not have an objection, Your Honor.
Okay, so we'll set this for another hearing about 90 days. And we'll proceed further at that time.
Your Honor, Mr. Michelle's did ask that the court address his bond. I believe a significant bond was set in this matter. I believe it was $50,000. Mr. Michelle's has very strong ties to the community. He owns a home here. He's concerned that he's going to lose the home and the equity in the home. He really wants to return to work, wants to return to parenting his daughter. He has family in the area. Again, he owns property in the area. And I would ask the court to consider a 10% option. Thank you.
Mr. McDowell, do you have any input on that?
Judge, I defer to the prosecutor.
Okay. Ms.
Your
McGregor?
Yes, Your Honor, in this matter, I argued for 150,000 cash surety, 10%. I think the court set the bond at 50,000 cash surety, no 10%. In this matter, at the time I had indicated that there would be charges that we were pursuing. Those charges have been signed off. I think PCC is next week. It's possession of methamphetamine, having a gun during the commission of a felony, and maintaining a drug house. As I indicated this week when I was in court, in district court, I think he's had 4 or 5 driving while license suspended. He pled to 2 of those this week on Tuesday. I asked for 93 days in jail at that time based on he continues to use meth, your pretrial release services. He tested positive during the pendency of the case. I think it's a huge safety risk to the community in this matter. He continues to commit crimes while on bond. I mean, he's making a mockery of the court. And when you look at this, he has PV violations for his charge. He was on 7411. The new charges are similar with possession of methamphetamine. I believe the bond is appropriate in this matter, Your Honor, to ensure safety. And he's had several failure to appears, not in district court, and he failed to appear for probation. That's why Mr. McFalden went out there and he was arrested on these charges. So for safety of the community, failure to appear, having him appear within court, I think the bond is appropriate in this matter, and I'd ask for it to stay, Your Honor.
Anything you wanted to say?
Just that Mr. Michelle's is denying that he failed a drug test, Your Honor. I don't have file in front of me, so I can't sort of verify that one way or another.
I've never
But I
been
just
tested.
want the court to understand that Mr. Michelle's is indicating he doesn't agree with the failed drug test as alleged.
All right. The gun that they found was an antique hanging on my wall.
Mr. Michelle's, don't talk
Sorry.
about what they found or didn't find or alleged to have found.
Sorry.
Okay. Well, I mean, it sounds like you're facing some fairly serious charges, Mr. Michelle's. And I think the bond is appropriately set given your past history, given the nature of the violations here. So I'm not going to modify the bond. We'll proceed as scheduled. Mr. Thompson, anything else we need to address?
Nothing further for today's record. Thank you.
Ms. McGregor, is there anything else we need to address for the record today?
No, Your Honor, thank you. Have a good day.
All right, thank you.